The Committee on the Judiciary, Subcommittee on the Constitution, Civil Rights, and Civil Liberties will come to order. Without objection, the chair is authorized to declare a recess of this subcommittee at any time. Before we go into our committee, I would like to express the chair, and I'm sure all the members of the committee and the Congress, sadness at the passing of Representative Wright. He served for a short period of time, but he was a gentleman, and we will miss him, and we mourn his loss. And I would like for us to have a moment of silence in his honor. Without objection. Thank you. Thank you. At this point, Mr. Johnson, if you would like to lead us in prayer regarding the passing of our colleague, you would be recognized.
Thank you for that, Mr. Chairman. Very much appreciated. Our colleague Chip Roy, who's joining us this morning, was on an interview this morning and knew Representative Wright as well as any of us and said so well. He was a good man, a good family man, and truly dedicated public servant to his constituents and to the country. So thank you for that. I'll lead us in prayer. Thank you. I would just pray, Heavenly Father, thank you for this day, for the work that you put before us, and for all of our colleagues. We're reminded this morning of the preciousness of life and how fleeting it is. And I pray that Representative Wright's example would be one that shines for all of us. He was truly committed to you and to his family and to his country and to all those he served. And so let that be a shining example for us. Let us be reminded of the value of one another, and that life is short, and we make the most of it. So we pray for the Wright family, all those involved, his constituents, everyone affected, all of our colleagues as well, and that you bless and continue to bless him and them and the work of our hands. I pray all this, I pray in Jesus' name, amen. Thank you, Mr. Chairman. Yield back.
Amen. Thank you. Very well done. Thank you. Now we'll go back to the committee. I welcome everyone to today's hearing on constitutional means to prevent abuse of the clemency power. Before we begin, I'd like to remind members, new and returning, that we have established an email address and distribution list dedicated to circulating exhibits, motions, and other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to Judiciary Docs, that's Judiciary DOCS, at mail.house.gov, and we will distribute them to members and staff as quickly as possible. I will now recognize myself for an opening statement. I'm pleased to convene the first hearing of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties for the 117th Congress. I look forward to once again working with the gentleman from Louisiana, Ranking Member Mike Johnson, and other members of our subcommittee on the many challenging and pressing issues that will be addressing us in the months and years to come. While we will no doubt have sharp disagreements from time to time, it is my hope that we'll always be able to disagree in the guardrails of mutual respect as colleagues. Each of us was sent here to represent our constituents faithfully and to the best of our abilities. We begin this Congress by picking up on a topic that we devoted 2 hearings to in the previous Congress, which is the proper scope and use of the President's constitutional power to grant clemency. The clemency power is outlined in Article 2, Section 2 of the Constitution, and is rightly broad. Clemency power purpose is to act as a safety valve for our criminal justice system, to correct system injustices, and to ensure that mercy tempers excessively harsh punishments. There are few things that more fiercely urgent than the need to grant clemency to the thousands who suffer from the burdens of excessive and unjust imprisonment or the collateral consequences stemming from their criminal convictions. Perhaps not coincidentally, these burdens are disproportionately borne by people of color. I have long been concerned with the stinginess with which modern presidents have granted clemency, beginning in the 1980s with the so-called war on drugs, which really goes back to the 1970s. Between 2013 and 2014, I wrote 4 letters to then President Obama and then Attorney General Holder, urging the President and the Attorney General to become more involved, to grant more clemency petitions, and I authored 2 opinion pieces on the subject calling for more clemency grants. In fact, I had written the president early in his second term and told him I had 3 C's I wanted him to work on: Cuba, cannabis, and commutations. It was alliterative, maybe somewhat effective, but he was a little shy on clemency. I also wrote to President Trump to commend him for commuting the sentence of Alice Marie Johnson and to encourage him to do more than his predecessor, who did issue a great number of clemencies, probably the most of anybody in recent time, but far from the amount of people that deserve them. And I asked him if he would do more in granting clemency to many cases like that of Ms. Johnson. It is my hope that President Biden will be a leading example of how clemency power could be more effectively used, especially among those who may be more deserving, but whose pleas have not been heard. The subcommittee will commit itself to pushing for more expansive use of the clemency power, an effort that I hope will be bipartisan, because we're talking about freedom, and we know both caucuses appreciate freedom. When considering what is the proper scope and use of the clemency power, however, there is another matter to consider, which is whether there are or should be limits on the power when a president grants clemency for self-serving or corrupt purposes, rather than as an act of mercy. Presidents of both parties have issued controversial pardons that raise these kind of questions, which is why they have been long-standing interest of this subcommittee. Such pardons are often not in keeping with the purpose of the clemency power. In 2019, the subcommittee considered the question of whether a president could issue a self-pardon, and the consensus among all of the witnesses at that hearing, including the one requested by the minority, was that on balance, the Constitution likely would prohibit self-pardons. Indeed, during the Nixon administration, the Department of Justice's Office of Legal Counsel concluded that self-pardons would be unconstitutional because of the basic principle that no one should be a judge of his or her own case. Questions about the proper scope of the clemency power took on greater urgency during the recent presidency. No president is permitted to abuse the power of his office to obstruct a law enforcement investigation, yet the manner in which President Trump used the clemency power throughout his presidency raised the concern that he may have been willing to do just that to protect himself and his political allies. For example, during the investigation of the special counsel Robert Mueller into possible Russian interference in the 2016 presidential election, President Trump on multiple occasions dangled the possibility of pardons for witnesses who refused to cooperate. Specifically, Paul Manafort, his former campaign chairman, Michael Flynn, his national security advisor, and Roger Stone, his senior campaign advisor. Ultimately, he would pardon all 3 of these individuals after their convictions for various criminal offenses stemming from the Mueller investigation during his final weeks in office. In addition to matters related to the Mueller investigation, President Trump used the clemency power in other potentially self-serving ways, as most of those who received clemency had some kind of special access or other political or personal connection to him. That seemed to be the thread rather than the crime and the sentence. This included clemency for 4 former Republican members of Congress, one of whom I was personally close to. Nevertheless, they had been convicted of various criminal offenses ranging from bribery and insider trading to misuse of campaign donations. Charles Kushner, his son-in-law's father, and his former chief political strategist, Steve Bannon, who was awaiting trial on fraud charges relating to a scheme to fund a wall on the U.S.-Mexican border, were also pardoned. President Trump also reportedly discussed pardoning himself and his children during his final days in office. We presume he didn't do that, but we don't know that for a fact because there is such a thing as a secret pardon, which is something we should address today. In light of the foregoing, I introduced H.J. Res. 4, a proposed constitutional amendment that would expressly prohibit presidents from granting clemency to themselves, prohibit clemency grants to certain classes of people like the president's family members to the 3rd degree, administration officials, paid campaign staff, or any person or entity who committed an offense directed by the president. It also has a catch-all provision making any pardon invalid, which was issued for a corrupt purpose. I'd introduced similar resolutions in the previous 2 Congresses. While this proposed amendment precludes clemency for certain potential recipients, I would also like to talk about ways to improve the clemency process, transparency, and the timing of pardons. and commutations. Specifically, I would like to hear the witnesses' views about requiring public notice of pardons to get around the issue of possible secret pardon, or commutations that might be issued before Election Day. I think Mr. Fawley had suggested some type of prohibition before Election Day, but it would have, or after the election, but it would have to have some time period and a requirement of notice. For if there was a secret pardon, it wouldn't be known. That would have to be addressed. So public notice of pardons or commutations, maybe a time before Election Day so that voters have notice. Not only in a presidential, obviously in a presidential election year, and probably only in the first term. Requiring more transparency to avoid secret pardons and revising the system by which clemency decisions are made, including removing or curtailing or otherwise amending the role of the Department of Justice with respect to the clemency process. This will not be our last look at the clemency power in this Congress, as the subcommittee will continue to engage on this issue, including from a criminal justice reform perspective. I thank our witnesses for being here, and I look forward to a lively discussion. And now I would like to recognize the gentleman from Louisiana, our ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. Appreciate that very much. Our Article 2, Section 2 of the Constitution includes very clear language. And of course, it says in relevant part, quote, "The president shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment," unquote. Some presidents, of course, have used this power more than others. They do this based upon their own conceptualization of justice, their own respective judgments, and most of the country has always respected that. For instance, President Trump issued 237 total pardons and commutations during his term of office in 4 years, 237. By comparison, President Obama issued 1,927 pardons and commutations. President Bush issued 200, and President Clinton issued 457. And so the numbers vary. President Obama issued pardons or commutations, many of which were very controversial. He, for example, included Chelsea Manning, who endangered national security by leaking classified information. Oscar Rivera Lopez, a top FALN leader and terrorist, and his Joint Chiefs of Staff Vice Chairman James Cartwright, who lied to federal investigators. President Bush commuted the sentence of Louis Scooter Libby, which was controversial in some circles. President Clinton issued pardons or commutations to his own brother for drug-related offenses, to fugitive political donor Mark Rich, to his CIA director, his housing security secretary, and several individuals who were convicted for their actions during the scandals of his own administration. Most recently, President Trump pardoned Roger Stone and Michael Flynn. All these presidents exercised their judgment and issued pardons that were controversial with the opposing party and with many segments of the public. But despite the broad use of the pardon power that has varied from president to president throughout our entire history, the majority introduced the Abuse of Power Prevention Act last Congress. Republicans explained that the bill was unconstitutional at a committee markup last July. Nevertheless, the committee favorably reported the bill on a party line vote. Additionally, the chairman recently introduced the proposed constitutional amendment that he just mentioned to narrow the pardon power. I have several significant concerns with this proposed amendment. Many of us do. Among other issues, it vaguely declares that, quote, "pardons issued for a corrupt purpose shall be invalid." The problem there is that it's pretty vague and overbroad language. There's not any framework or workable standard to determine what exactly amounts to a corrupt purpose. I'm sure that the majority would argue that certain pardons issued by President Trump were issued for a corrupt purpose, while most Republicans would argue they serve the interest of justice by ending politically motivated prosecutions. This very issue of partisan passions affecting the judgment of Congress is precisely why the founders structured the pardon clause exactly as they did. Alexander Hamilton argued against legislative involvement in the pardon power because he said, quote, "When the offense had proceeded from causes which had inflamed the resentments of the major party, they might often be found obstinate and inexorable when policy demanded a conduct of forbearance and clemency," unquote. James Madison similarly argued that legislative involvement in the pardon power would be improper because, quote, numerous bodies actuated more or less by passion and might in the moment of vengeance forget humanity, unquote. Similarly, a narrower pardon power was proposed during the Constitutional Convention for precisely the same reasons that the majority advances today. For good reason, that proposal was soundly defeated. The pardon power is best vested in the president, as it was designed in the Constitution, for a president to exercise as they see fit based upon their personal judgment and notion of justice. I thank our witnesses for appearing before the subcommittee this morning. I look forward to your testimony, and I hope we can have a productive conversation. Mr. Chairman, with that, I yield back.
Thank you, Mr. Johnson. Unanimous consent is requested for submission of the full committee chairman, Mr. Nadler's opening statement for the record. And I would ask for unanimous consent for that. Without objection, his statement will be entered into the record. The ranking member, Mr. Jordan, is present, and if he chooses to make a statement, he is recognized at this point.
Mr. Chairman, I'm fine. Thank you.
All right, Mr. Jordan, thank you and welcome. Now we'll go to witness introductions. We welcome our witnesses and thank them for participating in today's hearing. I will now introduce each witness, and after that introduction, we'll recognize the witnesses for his or her oral testimony. Please note that your written statement will be entered into the record in its entirety. Accordingly, I ask you summarize your testimony in 5 minutes. In the absence of the proverbial timing lights, the green, the yellow, and the red, I will note orally when 5 minutes have elapsed and bang my gavel, otherwise known as a Louisville Slugger miniature bat. There will also be a timer on your screen, so please be mindful. Before proceeding with testimony, I would like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to the subcommittee. Any false statement you may make today may subject you to prosecution under Section 1001 of Title 18 of the United States Code. Our first witness is Carolyn Fredrickson. Ms. Fredrickson is a distinguished visitor from practice at Georgetown University Law Center and a senior fellow at the Brennan Center for Justice at New York University School of Law. She teaches courses on the legislative process, constitutional law, and democracy. She was previously the president of the American Constitution Society for Law and Policy. She's also had an extensive career serving the government as special assistant to the president for legislative affairs during the Clinton administration, as chief of staff to Senator Maria Cantwell, and as deputy chief of staff and counsel for Senator Tom Daschle. She also served as a law clerk for the Honorable James L. Oaks of the U.S. Court of Appeals for the Second Circuit. Ms. Fredrickson received her JD from Columbia University School of Law, where she was a Harlan Fiske Stone Scholar and served as editor of the Columbia Law Review. She received her BA summa cum laude from Yale University. Ms. Fredrickson, you're now recognized for 5 minutes.
Thank you so much, Mr. Chairman. I'm really pleased to have the opportunity to appear before you today on this important topic. As has been said, the pardon power gives the president the power to address injustices and show mercy. However, the breadth of this power has made it susceptible to misuse. Just before leaving office in 1992, President George H.W. Bush pardoned former Secretary of Defense Caspar Weinberger and 5 others convicted in the Iran-Contra scandal. And President Bill Clinton's pardon to Mark Rich, a fugitive felon who'd been indicted for fraud and tax evasion and was the ex-husband of a major donor to both the Clinton Foundation and Hillary Clinton's Senate campaign, was rightly criticized. But former President Trump has gone even further in granting questionable pardons. On his final day, Trump pardoned 74 people and commuted the sentences of 70 others, including Salomon Melgen, who was convicted of defrauding Medicare to the tune of $75 million. The pardon power was intended to be a benevolent power, but there are several well-recognized limits on its exercise. It only extends to federal crimes. It may not be used to obstruct justice, and a self-pardon is constitutionally suspect. Congress could, of course, reform the pardon power by a constitutional amendment. And as the chairman's proposal would do, it would limit the president's pardon power to grant such a pardon to himself, his family, his administration officials, or campaign advisors, and would prevent pardons for conduct undertaken for a direct and significant personal benefit of the president, his family, officials, or for crimes committed in cooperation with the president. The chairman rightly states that the power often operates like a get out of jail free card, more than as a grant of mercy to those who've been clear victims of injustice. Congress could also reform the pardon power by creating statutory limits. There is a bill introduced by Representative Adam Schiff, which would propose two important reforms. In cases of covered offenses, his bill would require that DOJ and the president provide congressional committees with materials relating to the prosecution, as well as the pardon. And it would strengthen the bribery statute by clarifying its application to the president and vice president, that it's an official act to grant a pardon or commutation, and that such a grant is a thing of value. Thus, the amendment would ensure, or the bill would ensure, that any offer of a pardon or a pardon itself would be a criminal act if part of a corrupt exchange. And it would also declare presidential self-pardons invalid. There's strong reason to believe this legislation would withstand constitutional challenges. It's widely accepted that Congress may impose criminal penalties on a presidential pardon intended to bribe a recipient. Since the legislation does not attempt to circumscribe the actual grant of a pardon, it does not tread near the president's Article II powers. And DOJ has issued two opinions that are consistent with this understanding. In October 1995, there was an opinion that stated the application of the bribery statute raises no separation of powers question, let alone a serious one. According to OLC, the Constitution confers no power in the president to receive bribes as it specifically forbids any increase in the president's compensation for his service while he's in office, which is what a bribe would function to do, and because the Constitution expressly authorizes Congress to impeach the president for bribery. With respect to a president's pardon of him or herself, as is well known, in 1974, there was another OLC opinion that stated that such a pardon is illegitimate. There is another bill meriting consideration authored by Representative Krishnamurti, which would require the president to publish the issue date, recipient, and full text of each pardon or reprieve granted. Even if not limiting to whom or for what reason a pardon could be granted, such legislation would bring public attention to ill-considered grants. Another area where Congress can help police the pardon power is its oversight function. After President Clinton pardoned Mark Rich, Congress engaged in a thorough and bipartisan investigation. Although no criminal charges were issued, Congress did uncover some highly questionable behavior, including efforts by President Clinton's half-brother and brother-in-law to lobby for pardons in exchange for pay. As has been noted, the president's power is an awesome power, a power for good. It is often used, however, or it is not often enough used for good, and it is sometimes used in a way that's abusive. And Congress is right to take up the task of restoring the pardon to its status as a benevolent power. Thank you.
Thank you, Ms. Frederickson. You've obviously been here before because you know how to do 5 minutes on the nose. Our next witness is Karen Hobart Flynn. Ms. Hobart Flynn is the president of Common Cause, a position she's held since 2016. Common Cause is a nonpartisan grassroots organization dedicated to upholding the core values of American democracy, working to create open, honest, and accountable government and promote equal rights and opportunity for all and empower people's voices in the political process. Ms. Hobart Flynn has been with Common Cause for the last 28 years in various capacities. In that time, she's worked to expand Common Cause's efforts with respect to election administration reforms, curbing the outsized influence of big money in politics, and ethics and accountability reforms. She has written and spoken frequently on democracy issues, including about influence of money in politics, voting rights, and ethics and conflict of interest reform for elected officials. Ms. Hobart Flynn, you are recognized for 5 minutes.
Thank you, Chairman Cohen, for inviting me to testify at this important hearing. Mr. Chairman, Ranking Member Johnson, and members of the subcommittee, I am pleased to be here as president of Common Cause, a national nonpartisan organization with more than 1.5 million supporters working for an open and accountable democracy. The pardon power is a potent tool to advance justice. Unfortunately, it can also be misused to obstruct justice. This warrants congressional action, and I hope my testimony today will help you with your task. First, I must say that no discussion about executive clemency is complete without first acknowledging the broader problems of our criminal justice system. Systems of mass incarceration continue to ravage communities, often violently wrenching Black and brown people out of their homes and dumping them in steel cages at alarming rates. Racist public policies continue to have disparate, inequitable impacts on Black and brown people and communities. Until Congress passes sweeping criminal justice reform that roots out racism, classism, and xenophobic policies and practices in all levels of the justice system, we must encourage the president to use clemency as a tool to chip away at injustice, as President Obama did during his term, and I discussed further in my written testimony. But elections have consequences, including those for seeking clemency. Many of President Trump's pardons rewarded his white wealthy friends, including war criminals, former aides, corrupt insiders, and others who obstructed justice by lying to Congress and law enforcement. This is a challenge we have seen with some other presidents. More importantly, we believe that President Trump abused the pardon power to send a message that he and his associates viewed themselves as above the law. In his words and deeds, President Trump signaled his intent to reward obstruction and subvert accountability to further his own political power. His efforts were open and notorious. Special Counsel Mueller detailed this in his report, noting that, quote, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, took place in public view, end quote. Among those pardoned, Michael Flynn, who twice pleaded guilty to lying to the FBI, his former campaign chairman, Paul Manafort, who encouraged witnesses to lie on his behalf, Roger Stone, convicted of obstructing Congress's investigation into foreign election interference, lying under oath, and witness tampering. There are also very serious questions about how the pardon power could be used for illegal bribery for pardon schemes, as public reporting late last year indicated the Department of Justice was investigating. There are steps Congress must explore to rein in the abuse of the pardon power. First, some reforms would require a constitutional amendment. HJ Resolution 4 by Chairman Cohen puts forward a number of strong proposals to curb self-dealing and evasion of accountability, including invalidating pardons issued for corrupt purposes. Even without a constitutional amendment, Congress has the power to otherwise check the abuse of the pardon. The Abuse of the Pardon Power Prevention Act in the 116th Congress, which was included in the Protecting Our Democracy Act, provides important oversight, transparency, and anti-bribery and self-dealing protections. We urge its reintroduction and passage this Congress. In the meantime, Congress should also investigate whether President Trump's pardons to his associates and others were otherwise corruptly granted, and share what it learns with the American people. Congress should also explore the idea of independent clemency boards to review clemency petitions and advise the president. This could eliminate biases and conflicts of interest inherent in the current system, which often relies on prosecutors at the Department of Justice to serve as a check on their own prosecutions. Members of such a clemency board should reflect our country's diversity and be representative of stakeholders inside and outside the criminal justice system. Mr. Chairman, I believe that democracy is resilient, but it takes work to ensure that it lives up to its promise. It will continue to be stress tested. I urge the committee to take the steps that are necessary to advance justice for all, protect the rule of law, and end the racial inequities in our legal system. The pardon power is one important part of what must be a comprehensive approach. Thank you, Mr. Chairman, and I look forward to the committee's questions.
Thank you very much, Ms. Albert Flynn. I appreciate your testimony and your service with Common Cause. Our next witness is Mr. Josh Blackman. He is a professor at law at the South Texas College of Law in Houston, Texas, where he specializes in constitutional law, law and technology, and the study of the United States Supreme Court. He is the author of 59 published articles, 3 books, and numerous amicus briefs, and is the editor of a case book on constitutional law. He received his JD magna cum laude from George Mason University School of Law, where he served as articles editor of the George Mason Law Review. He received his BS magna cum laude from Penn State University, the Pennsylvania State University. He was a law clerk for the Honorable Danny J. Boggs of the U.S. Court of Appeals for the Sixth Circuit and for the Honorable Kim Gibson of the U.S. District Court for the Western District of Pennsylvania. Professor Blackman, you are recognized for 5 minutes.
Thank you. Chairman Cohen, Ranking Member Johnson, thank you for inviting me to testify. My name is Josh Blackman, and I'm a constitutional law professor at the South Texas College of Law at Houston. People often think that the courts have a monopoly on interpreting the Constitution. They don't. As we speak, the House managers are trying President Trump for violating the Constitution, and here we will discuss the constitutional means to prevent abuse of the clemency power. In my brief opening remarks, I'd like to make 3 primary points. First, I will discuss an important purpose of the pardon power. Second, I will consider proposed statutory regulations of the pardon power. And third, I will talk about H.R. 4, a proposed constitutional amendment that would limit presidential clemency. Today, people often view the pardon power as a form of error correction. For example, the courts made an error by imposing an unjust sentence, or prosecutors pursued an unjust charge. But as originally understood, clemency could serve a greater purpose. In Federalist Number 74, Alexander Hamilton identified the, quote, principal argument for the pardon power, quote, restoring the tranquility of the Commonwealth. Pardons do not merely help individuals. Presidents can issue pardons to advance broader public policies. Some of the most famous pardons in American history serve this purpose. President Washington pardoned participants in the Whiskey Rebellion. President Jefferson pardoned those convicted under the Sedition Act. After the Civil War, President Johnson pardoned former Confederates. Each of these decisions was unpopular in some quarters, but in each case, the president used his pardon power to pursue the common good as he saw it. This history brings me to my second point. Last summer, this committee marked up the Abuse of Pardon Prevention Act. I criticized this bill in a post I co-authored for Lawfare with my colleague Seth Barrett-Tillman, who was a lecturer at the Maynooth University Department of Law in Ireland, and I will submit that post for the record. In short, this proposed bill would alter the presidency such that he would now second-guess his official actions for fear of prosecution. Congress should not empower federal prosecutors through the power of the criminal process to dictate what the public interest is. Third, this committee is considering H.R. 4, a proposed constitutional amendment that would limit whom the president can pardon. I oppose this amendment. It attempts to constitutionalize a single conception of the public interest, what is and is not a proper pardon. The public interest is always contestable because no one has the institutional knowledge to declare a monopoly on what is in the common good. The president should be able to make important decisions with vigor, independence, and dispatch. The president should have the greatest latitude to issue pardons precisely because the president should have the greatest latitude to pursue what he sees as the common good. Limiting the president's power to issue pardons will limit the president's power to promote what Hamilton referred to as the tranquility of the Commonwealth. This amendment should not be adopted. Thank you for your time, and I will be happy to answer any of your questions.
Thank you, Professor. I appreciate your testimony. We now would like to recognize our next witness. And I'm going to have to ask you to help me with the pronunciation of your name. Is it not Vali? Professor Naftali, is that correct? I'm going to presume it's correct. So our next witness is Timothy Naftali, and I've seen him on television 1,000 times, well, dozens of times, and I never get his name quite right. He's a clinical associate professor of public service, clinical associate professor of history, and director of the undergraduate public policy major at New York University. He focuses on national security and intelligence policy, international history, and presidential history. He served as a consultant to the 9/11 Commission and recently co-authored a book called Impeachment in American History. He's also the author of a December 2020 article in the Atlantic magazine titled Trump's Pardons Made the Unimaginable Real. Prior to NYU, he served as the founding director of the Richard Nixon Presidential Library and Museum in Yorba Linda, California, and I kind of guessed that he's considered the top expert on President Nixon. Professor Naftali received his PhD and MA in history from Harvard, an MA with distinction from Johns Hopkins School of Advanced International Studies, and a BA magna cum laude with a distinction in history from Yale University. Professor Naftali, you are recognized for 5 minutes.
I wish to thank the chair, Mr. Cohen, the ranking member, Mr. Johnson, and members of the House Judiciary Committee Subcommittee on the Constitution, Civil Rights, and Civil Liberties for the privilege of testifying to you today. Concerns about the breadth of the president's clemency power and the desire to, in some way, reform it are not new to this moment in our history. It is not solely a product of these deeply partisan times. It is not an unprecedented knee-jerk reaction to the conduct of our 45th president. According to Fordham University Law School's Democracy and the Constitution Clinic, on 41 separate occasions since 1974, members of Congress from both parties have introduced legislative proposals designed in one way or the other to modify the president's use of executive clemency. And over half of these initiatives were introduced before the year 2001. Indeed, 20 years ago, almost to the day, this subcommittee held a similar hearing on the presidential pardon. The catalyst then was concern and disappointment on both sides of the aisle in how and to whom President Clinton had issued 140 pardons and 36 commutations on his final day in the White House. Most notoriously, one to Mark Rich, a fugitive facing criminal prosecution for tax evasion, whose former wife was a donor to the Clinton Library. All of the panelists 2 decades ago cautioned this subcommittee not to amend the Constitution, reflecting confidence that the Clinton pardons would be an aberration because of the criticism they had inspired. Quote, "I very much doubt that future presidents will need to be restrained in their use of pardon power," one panelist argued, given the in terroriam example of the final Clinton grants. I quote our distinguished predecessors with humility. Who knows how well today's testimony will age in 20 years, let alone the rest of us. But I think I can say as an historian that history can only act as a deterrent to bad behavior if we all know it. The last few months, let alone the last 20 years, suggest, at least to this scholar, that we were far too optimistic about presidential pardon behavior 20 years ago. The Clinton pardons should have led to concrete federal corrective action. Today, I will leave most of the discussion of legal precedents to my fellow panelists who are lawyers. Perhaps my value to you is in using this statement to share some history indicating the perils of an unreformed presidential clemency power and how a few presidents, one of whom later became Chief Justice of the Supreme Court, looked at the matter. The only president to have joined the Supreme Court after leaving office, of course, was William Howard Taft. And therefore, he is a unique witness, if you will, on looking at the pardon from both the perspective of 1600 Pennsylvania Avenue and that of the Supreme Court. In a book that he wrote as a law professor before he came back to federal service, when he was appointed to the court, he wrote, "The duty involved in the pardoning power is a most difficult one to perform because it is completely within the discretion of the executive and is lacking so in rules or limitations of its exercise. The only rule he can follow is he shall not exercise it against the public interest." When he became Chief Justice, he had to look at a case that involved contempt of court. The question that was raised was, can the pardon be used in a way to protect those whose actions threatened our very system of justice. And he concluded, yes, the pardon power is unfettered. But, he added, there is always the possibility of impeachment as a corrective action, as a deterrent. My belief in the need for corrective action is founded on what I learned about our nation's 37th president, Richard Nixon, from publicly available materials at the Nixon Library when I was director. In my prepared statement, and in our questions perhaps, I will detail or discuss the cynicism and the lawlessness that attached to President Nixon's approach to the pardon power. Although he did not issue the pardons that he dangled, his dangling of pardons not only became part of Article 1 that was passed by your committee in a bipartisan matter in 1974, but no doubt led to perjury. Therefore, even regardless of our 46th president, the Nixon precedent alone is an argument for not allowing this power to be unrestrained, particularly in a partisan age where the tool of impeachment, I would argue, is no longer as much of a deterrent on bad pardons as our founders who lived in a pre-partisan age assumed it would be. Thank you for your time. I welcome your questions.
Thank you, Professor. Appreciate your being with us and your life's work. We'll start with questioning now, and I will take the first round of questions. We will have the end of the 5-minute rule, and I'll recognize myself for 5 minutes. First, I'd like to ask Ms. Hobart Flynn, according to your testimony, President Trump's clemency grants overall, quote, created the appearance and reality of a two-track justice system, one for the president's associates and another one for everyone else. Why is even the appearance of impropriety in the granting of a presidential clemency so dangerous to our democratic order and the rule of law generally?
Thank you for the question. You know, one of the challenges is that we see the actions of our president can have real impact, and it can undermine people's view of government. One of the things that I think distinguishes President Trump's pardons from those of his predecessors, including, you know, pardons that are granted to the wealthy and well-connected, we saw other presidents do this, was a challenge around, you know, many things that happened during his term. He dangled pardons as a way to signal that he would excuse anyone who refused to cooperate with the Mueller investigation, and reward anyone willing to lie to them. And he did just that when he pardoned Mike Flynn, Paul Manafort, and Roger Stone. As recounted in Special Counsel Mueller's report, Trump criticized witness cooperation with the Mueller team, referring to cooperation as flipping and stating that flipping was not fair and almost ought to be outlawed. That's a quote. President Trump commented that it was very brave that his former campaign chairman, Paul Manafort, did not flip. And in response to a question about a potential pardon for Manafort, Trump said it was never discussed, but I wouldn't take it off the table. Why would I take it off the table? End quote. Meanwhile, President Trump's lawyer, Rudolph Giuliani, raised the possibility of a pardon for Manafort in interviews with the press, telling the New York Daily News, for example, when the whole thing is over, things might get cleaned up with some presidential pardons, end quote. These kinds of actions raise the specter that the president is above the law and can use something like a tool, the presidential pardon, in ways to help himself. And that is not what the founders thought of when they were talking about the pardon. The power of the pardon is extensive, but it needs to be viewed in the context of other provisions of the Constitution that requires the president to uphold the law and the Constitution. So this is not a tool to put his own, you know, his own worries about how he could be judged in the Mueller investigation in terms of Russian interference. And that
Ms.
kind
Hobart
of
Flack,
activity is undermining to people's view of their government.
in fact, let me go to Ms. Frederickson, although you would be just as a good a witness for this. The appearance of a conflict of interest is important. And Professor Blackman said certain changes should not be constitutionalized in prohibiting clemency because of a single conception of the public interest. Well, aren't there certain classes of people, Ms. Frederickson, that would have an inherent conflict, such as family members or possible close associates, that it would destroy the public's integrity, belief in the integrity of the presidency and of the clemency process and of all justice for all, equal justice for all?
Well,
Ms.
I think that's absolutely true, Mr. Chairman, that there are certain classes of people for whom the grant of a pardon raises immediate questions about conflicts of interest, self-interestedness, and lack of public interest. As Chief Justice Marshall said in 1833, the pardon power is supposed to be an act of mercy. That's the historical origins of it. That's what the framers of the Constitution believed it was designed to do. It was a benevolent power. It wasn't a power to grant oneself and one's family a get out of jail free card, or the ability to solicit funds for campaign donations in exchange for a pardon.
Let me ask you this, Ms. Frederickson, my 5 minutes about up. But you mentioned in your testimony about somebody that committed like $25 million worth of fraud, and there was something, I think, a pardon of a man in Florida who had done Medicaid fraud, and a man in another state that had done different fraud. There were a bunch of frauds in the tens and tens of millions of dollars. Could that in any way be seen as just as one of the statements about just a difference of opinion of the political parties and how they view justice?
Well, that's starting to get into the gray area. I think what is most the committee and the legislation that we're considering is most appropriately focused on quid pro quo pardons, which are certainly out of the bounds. I think the constitutional amendment could clearly get at a more circumscribed view of the public interest. I don't understand how it could be in the public interest to pardon somebody who has ripped off the government and Medicare for $75 million worth of funds by encouraging ill senior citizens to have more treatments than they needed. It's hard to contemplate how that could possibly be in the public interest.
Thank you, Ms. Frederickson, and my time is over, and I'd like to recognize the ranking member, Mr. Johnson, at this point.
Thank you, Mr. Chairman. I've got a few questions for Professor Blackman, and I just wanted to start first and clarify something. Isn't it true that the Supreme Court has long affirmed that the president's pardon power is not subject to any legislative control at all?
Absolutely. Going back almost 160 years, there was a case called Ex parte Garland. In that case, the Supreme Court held that there's basically no limitations in the pardon power. And this really hasn't been challenged by the Supreme Court. They've reaffirmed in other cases since. So I think your reading of the case law is correct, Representative.
So thank you for clarifying that. I think it's important for the full context of all this. And you've also, as you noted, you publicly opposed House Joint Resolution 4. Among other things, it would invalidate any pardon issued for a corrupt purpose. That's the quote, the language taken right out of the resolution. What's your understanding of that phrase, and why is that so problematic?
I think it's really important that we focus on the word corrupt. The chairman mentioned this word corrupt. My good friend Carolyn Frederickson mentioned the word corrupt. This is a word in which people disagree. Federal prosecutors often have a lot of difficulty proving what is a corrupt intent. You know, the classic example, I give a politician a suitcase full of cash in exchange for some sort of public service. Okay, I'm okay with that. That's corrupt. But when we're talking about something a little bit more blurry, for example, when someone says there's some sort of unjust prosecution, and he determines that in order to end this unjust prosecution, we need to issue a pardon. Under the proposed statute, that could be a thing of value, right? You're giving a thing of value to perhaps end an investigation, but that's still a public act and one which the president has. I'll be very hesitant to push the boundaries of what is and is not a bribe in a constitutional amendment or this proposed statute.
Thank you for that. House Joint Resolution 4 is not the first time, of course, that our Democrat colleagues have used legislation about pardons to target President Trump. Last Congress, Representative Adam Schiff introduced H.R. 7694, the Abuse of the Pardon Prevention Act. This committee reviewed that legislation last summer. Professor, you authored an article concluding that the bill would have criminalized politics. And can you elaborate on that a little bit, explain what the problem is there?
Sure, and I think the statute suffers from a similar problem that the amendment does. It uses this word corrupt and allows federal prosecutors to decide when the president's acting in the public interest and when he's not. Basically, corrupt is going to be the opposite of whatever the prosecutor thinks is the public interest. And I think it's dangerous. The pardon is a political act. It's a public act. I actually agree with the chairman that the secret pardons are problematic, and I'm gonna go with him on that one. But to the extent that these pardons are public, the president can take the political flack for it. And if there's an abuse of power, impeachment's the remedy. James Madison said so 200 years ago. I don't think that legislation or even an amendment is the right way to ex ante in advance try to limit this authority.
Very good. This may be my last question. We're running out of time, but I was intrigued by what Professor Naftali just testified to in his premise that there are some pardons that are so egregious that it really does require the Constitution or some other corrective action, as he said. And he noted President Clinton, who is probably the most notorious abuser of the pardon power, at least in the modern era, for all the things he did. I wonder what your reaction is to your colleague there. And although there are some very egregious examples, does that mean now that we should change the Constitution wholesale?
I think, and I'm grateful for my friend Professor Naftali's remarks. I think the remedy should be after the fact, not before the fact. I mean, today we're seeing that they can impeach a former president. Apparently, that's the new rule. And so if a president decides to engage in sort of misconduct in the last month or two of his term, there are political remedies. But I think trying to legislate in advance is problematic because now whenever the president considers, do I issue a pardon? Do I not? He's always thinking, man, if I issue this pardon, I'm going to get in trouble. Will some federal prosecutor, the next Robert Mueller, try to indict me because they issue this pardon? That's a chilling effect I think is problematic. And I think this body, Congress, can use oversight after the fact rather than chilling beforehand.
I got 30 seconds left. Let me just ask you a mechanical question because there's a lot of confusion about it. What's the role of the Department of Justice's pardon attorney in all this, the recommendations they make?
The DOJ is purely advisory. The Attorney General and his subordinates make recommendation, but ultimately it's the president and the president alone who decides whether to check yes or no in that pardon box.
Very good. With 7 seconds left, I'll yield back, Mr. Chairman. Thanks to all the witnesses.
Thank you, Mr. Johnson. Next for questioning is Ms. Ross, a new member from North Carolina, and you're welcomed and you're recognized.
Thank you so much, Mr. Chairman, and thank you to all of the witnesses. This has been a fascinating morning, and thank you for your perspectives and for your scholarship. I have a couple questions for Ms. Fredrickson, just to narrow down when there could ever be an abuse of the pardon power. And the first question is, can the president's exercise of the pardon power, clemency, ever violate our current criminal laws prohibiting obstruction of justice or bribery?
Thank you very much for that question. And I was neglectful in not saying to my colleagues from academia and from advocacy, what a pleasure it is to be here. And Josh and I go way, way back. I have to say I first met Josh when he was a young law clerk. But anyway, so we're good friends and it's good to be here. Your question is a very important one, and I appreciate it. As I stated in my written testimony, there is actually already wide consensus that certain kinds of pardons could be considered criminal acts. That is, in the example that Professor Blackman used, I think the bag of cash or the suitcase of cash. I like bag of cash better. It has more better visual. So the bag of cash in exchange for a pardon. Most scholars, most constitutional experts believe that is already a criminal action, and efforts to obstruct a judiciary proceeding would also, to suborn testimony of a witness, for example. However, one of the things that the legislation would do is to clarify the statute to make it even more clear that the bribery statute applies to the president and vice president, and that a pardon is a thing of value. And so that is why, although the law is well understood already to cover that type of behavior, it would be prudent to make it more explicit.
Okay. Well, you've done a great job because you've already answered my second question in answering my first question. So thank you for that. But then my next question really goes to the issue of, so if the president does violate this criminal law, the bribery statute or obstruction of justice, either in its current form or if it is amended, the Department of Justice has said that a sitting president cannot be criminally prosecuted. Do you agree with that? Or do you believe that it would have to wait until after the president completed his or her term?
Well, I don't tend to agree with it as a legal matter, as a prudential matter. It makes a certain amount of sense to postpone such an activity till after, and it really depends on what the criminal act was. However, it certainly, I think, is generally expected that in case of the abuse of a pardon, it would happen after a presidency, because most pardons, especially ones that are highly controversial, like the Mark Rich or Steve Bannon pardons, are issued right at, often even on the fading last moments of a presidency. And so unless there's I think Professor Blackman, who seems to concede that one can impeach a president who's left office for questionable pardons, but one could also certainly criminally prosecute.
Okay. And so I just want to be very clear with this last minute. You see, after the president has left office, two avenues to pursue a presidential violation of the law for obstruction of justice or bribery. Of course, the Congress could impeach. That itself is in the Constitution after the grant of the pardon power. But there also could be a criminal prosecution brought by the Department of Justice or a federal prosecutor. Is that what you're saying?
Yes, and I would actually want to quote then Senator and future Attorney General Jeff Sessions, who, in speaking about the Mark Rich pardon, said it qualified absolutely. He couldn't find a better example of quid pro quo bribery, and it was a criminal act. And there are certainly many conservative scholars who share that perspective.
Thank you very much. And Mr. Chairman, I yield back.
Thank you, Ms. Ross. If I'm incorrect in my order, Mr. Johnson, you can correct me. It's your team, but I think Mr. Jordan would be next, or Mr. McClintock. Which Mr. Johnson? Who wants to seek recognition next, Mr. Jordan or Mr. McClintock?
We'd probably go to Mr. Jordan if he's ready.
I guess
He may not be.
Let's go to
Mr. McClintock. Thank you.
You're welcome.
Oh, great. Thank you, Mr. Chairman. Perhaps the most egregious recent example of politicized prosecutions came with the Mueller proceedings, and the prosecution of Michael Flynn. Mueller's prosecutors falsified documents to the FISA court. They withheld material evidence from the court. They held interviews under false pretenses. They operated in an entirely partisan manner, where Republicans were singled out while the actions of Democrats in initiating the entire Russian collusion hoax were ignored. Just because the targets of this politicized process were associates of the president doesn't make these actions any less egregious or the injustice any less offensive or the remedy any less necessary. There were a number of pardons issued by President Trump and his predecessors that I've cringed at, and I'm sure I'll be outraged at pardons this president will make. But I think the importance of the pardon power in rendering justice in matters like the Mueller investigation argue against any limitations on it. I can't believe the founders didn't give great consideration to the frailties of human nature in assigning this power to the president. Professor Blackman, could you discuss in greater detail the reasons the founders offered in writing this provision of the Constitution as they did, and how they might reply to some of the objections we've heard today?
Thank you so much, Representative. The framers modeled the pardon power after the prerogative of the king, which was basically an almost absolute power. There are two limits, only pardons for federal offenses, and you can't pardon impeachment. Beyond that, there's really no discretion. During the Constitutional Convention, there were debates about whether the Congress should have a role in the pardon power. For example, whether the Congress must approve of a pardon, and those proposals were voted down. And I think that history tells us that the framers viewed this power should be residing in a single person, the president. I see over your shoulder George Washington, our first president. He very famously issued pardons to those who were in the Whiskey Rebellion. This was basically an uprising, insurrection, perhaps not too dissimilar to what people think happened a few weeks ago at the Capitol. Washington pardoned the people in the Whiskey Rebellion to make peace, to bring tranquility to the nation. It was controversial in some quarters, but I think it did a lot of very important work. And I think it's why one person, the president, should have that discretion to decide how to pursue the common good.
Well, I'm sure they must have foreseen, just human nature being what it is, that there would be a president who would issue pardons for partisan reasons, for personal reasons. I can't believe they didn't take that into consideration as they wrote this provision. What would they be saying about some of the arguments we've heard from the other side?
Well, there were debates in the Philadelphia Convention as well as the Virginia Ratifying Convention about abuse of the pardon power. George Mason, who was invoked earlier, was very much worried about the president basically using the pardon to cover up his own crimes. And James Madison said the remedy in that case is impeachment. And I think that's probably the right answer. The pardon itself will remain valid, but the president can be convicted, removed from office, and apparently now under the prevailing wisdom, he can be convicted even after he leaves office. So there's still some teeth in Congress to punish them. But again, these are public acts, right? I don't like the secret pardons. That's not how this is supposed to work. It's a public act. We know what it is, and the president can be judged politically for his actions.
Thank you.
Thank you.
You're back.
Thank you, Mr. McClintock. Next is the distinguished gentleman from the great state of Georgia, the Peach State, and the home of the Atlanta Airport, and one of my favorite chicken restaurants, Mr. Hank Johnson. Mr. Johnson there?
Just trying to get unmuted, Mr. Cohen. I want to thank you, Mr. Chairman, for holding this very important hearing, and I'm looking forward to serving on this subcommittee and to participating in the important work of repairing our Constitution. Like so many parts of our Constitution, the pardon power has been repeatedly abused over the past 4 years. In the cases of Roger Stone, Paul Manafort, Michael Flynn, Steve Bannon, and so many others, Donald Trump used the pardon power to shield himself and thus obstruct justice and to help cronies rather than using that unbridled power to correct injustice and excess in the criminal justice system. His abuse of the pardon power was egregious and unprecedented and shocks the conscience. Ms. Frederickson, why didn't the framers include limits on the use of the pardon power in the Constitution? And do you believe that there should be limits on the use of the pardon power?
Well, thank you very much for that question. And I have to say, I unfortunately don't know the restaurant that the chairman was referring to. I'd like to find it next time I'm in your district. So I think it's hard to know from the discussions exactly the scope of their thoughts around the pardon power, but historically it had not been considered for use outside of this idea of being used as a benevolent power or as an act of grace. And so, although George Mason did raise his concerns and his worries were assuaged by James Madison, as was mentioned, this was sort of a novel territory in many ways, because the king himself had not been subject, for example, to prosecution in the normal court system, and so the idea of a self-pardon, for example, and things like that were just not things that had been contemplated. And then, of course, as Professor Blackman said, that impeachment was seen as a possible approach to that kind of abusive pardon. Again, I think emphasizing why it's a legally correct position to be able to prosecute or to impeach a president after leaving office, because otherwise you can never, in the theory of that pardons can't be prosecuted, you could never actually get after that kind of an action. But so I think that there was not really a contemplation of the kind of criminal actions that might take place that a pardon might be used for, which does not mean that the founders thought that everything possible that a president could do was exempt under his Article 2, Section 2 powers to pardon.
Well, let me ask you this. During the Trump administration, we watched time and time again as President Trump shamelessly dangled the promise of a pardon to keep potential witnesses against him silent. To your knowledge, has any other president in the history of this country ever so abused the pardon power?
Well, you know, as Professor Blackman has noted, there has been this the possibility of secret pardons. So to some extent, we may not know, but certainly this past 4 years has raised significant concerns about the pardon being used as an obstructive device, as a way of obstructing justice, as a way of obstructing actual proceedings in court, which I think there, you know, as I said earlier, it's a very widely held position that those kinds of actions are actually crimes in and of themselves. And so therefore, even if the president could pardon somebody for an initial act, the act of exchanging a pardon for suborning testimony would be a crime separate from the one that was pardoned by the president and could be subject to prosecution.
Well, let me ask, thank you, ma'am. Let me ask Ms. Hobart Flynn, did President Trump's abuse and perversion of the pardon power do damage to our democracy, and if so, how?
Thank you. I think it has done damage to our democracy because it sends a message, which President Trump talked about frequently, that he is somehow above the law. He talked about shooting someone in the street and nobody doing anything about it. Pardoning people who could testify against him shows an abuse of the pardon power. And it is one where Americans want to see guardrails put on again and common sense solutions to be tackling some of these issues.
Thank you, Mr. Natali. After President Trump's excesses, how should Congress act to curtail the abuse of the pardon power?
Well, I want to repeat that I'm not a lawyer, so I'm going to speak as someone who studies power, as a historian. I believe that, as Chief Justice Taft wrote in Ex parte Grossman, that there is in a sense that there are checks and balances on the pardon, and that we should see the pardon within the framework. I'm going beyond what Chief Justice said. Within the framework of our constitutional checks and balances. And if we find evidence that a president has either ignored the restraints that our founders hoped would be on him or someday her, or we find that those restraints were not sufficient, we have to ask ourselves whether Congress, as part of its role and responsibility in maintaining the system of checks and balances, ought to take corrective action. And I argued in my testimony, not talking about Donald Trump, but talking about Richard Nixon, that you have a body of remarkable evidence of corrupt intent that is available to everybody in this country. And what Richard Nixon understood was that no one could stop him. And he came up with a series of corrupt ideas for using the pardon. He was going to have an amnesty. He was going to pervert the concept of amnesty, which had been used previously in our history. Professor Blackman talked about the amnesty for Whiskey Rebellion, those in the Whiskey Rebellion. There were amnesties after the Civil War. There was an amnesty that President Carter signed regarding the Vietnam War. President Nixon perverted that idea in order to find a way to cover releasing the Watergate burglars. So he looked for Democrats, in this case, anti-war dissenters, members of Vietnam Veterans Against the War, who had been indicted, and ultimately, by the way, were cleared of this, had been indicted for planning to disrupt the 1972 Republican Convention. He said, please keep them under indictment. Hold them under indictment. This is on tape. He said, we need them under indictment so that after the election, we can let them go. I'll pardon them, and I'll pardon the Watergate burglars. That way, there'll be a pardons on both sides. Then his chief of staff, White House chief of staff, Bob Haldeman, said, we don't have enough of these dissenters in jail. There are only 6 of them, the implication, and there are 7 Watergate burglars. He said, we can find reason to arrest more veterans, Vietnam veterans who are dissenters. We'll put them in jail so that we have a balance. Now, that is absolutely the most corrupt way of thinking of the pardon, but they thought this way. Now, the question we need as Americans to think about is whether the Nixon team were an aberration. Were they the only corrupt people ever to be in the White House? Were the only people, was President Nixon the only American president who saw this pardon as a get out of jail free card, as a way of manipulating our judicial system for political, personal gain? And I don't think so, regardless of where you think about Donald Trump. And I'm making this point here that there's enough evidence for corrective action without even talking about the 46th president. Now, my view of the 46th president is public. I have written about my concerns about his use of the pardon, about other elements of his administration. But I'm not making an argument for corrective action on the basis of Donald J. Trump. I say there's enough historical data that the system wasn't working before him. And now the outrage of those worried about the Trump era should combine with the continuing outrage of people worried about the Clinton era. You should work together. And my preferred approach would be a constitutional amendment. But I'm not a lawyer. My sense here is that the founders, God bless them, right? The founders made a few mistakes. In fact, that generation admitted it. They didn't think there would be parties. So they put together an electoral system that resulted in a tie vote because they never imagined that a president and a vice president would run on the same ticket.
Well, we're still cleaning up wreckage after 2 Republican presidents, and I think your testimony is quite elucidating, and I thank you for it. And with that, I will yield back.
Thank you, Mr. Johnson, and thank you, Professor, and thank you for gauging it in terms, which is what this committee is intended to do, is a bipartisan approach to correcting a problem that has been bipartisanly misused on occasion. Mr. Roy, you're recognized next.
I thank the chairman. I first want to just say thank you for recognizing our colleague, Ron Wright, at the outset of this hearing. Mr. Chairman, it means a lot. He's a good friend, fellow Texan, and we're all praying for his family, his wife, Susan, and we'll look forward to celebrating his life later this week. Secondly, I would like to just raise one issue that I think I heard from one of the witnesses, Ms. Flynn, about the extent to which pardons were used to reward white, wealthy friends, including war criminals, corrupt insiders. All these actions advance a cynical, corrupt, separate system of justice under President Trump. I mean, look, the pardon power has been used since the very beginning for political purposes. I mean, we can go back to Jefferson. We can go back to every president has done something. And I'd say, I guess that Mr. Natale is basically trying to say that, saying there's some systemic problems, that it cuts across both lines. But that kind of a partisan attack on President Trump, I just wanted to say that I think that, there are some people that might take issue with it, like Alice Marie Johnson, like a host of people, that criminal justice reform activists were advocating that President Trump help, and that the president did, in fact, help. So that broad brushstroke characterization, I think, is wrong and unfortunate, and shouldn't characterize this hearing. I think that the chairman is trying to put together a objective hearing here to try to figure out, what we might want to do on the pardon power. So I think that's an important part of this. I would also note that, there's been a number of controversial pardons. I don't that we've talked about every single one of them cutting across both lanes. And indeed, the chairman of the Judiciary Committee, Chairman Nadler, was instrumental in pushing for pardon of I think it was the Rosenbergs that were a part of the bombing of the United States Senate in 1983. I mean, it's not the first time the Capitol's been attacked, y'all. This kind of thing has happened. I hope that some of the people involved this year end up in jail like the Rosenbergs. But the chairman of this committee asked Bill Clinton to pardon these individuals who literally blew a bomb up in the United States Senate targeting members of the body in the Capitol. So this is obviously nothing new, and something that I think we ought to be thinking through. The one question I'd have, Mr. Blackman, I'd like your opinion. As we talk about reforms, one of the primary concerns I have about the draft amendment to the Constitution, the Texas Constitution, and look, far be it for me to ever say anything negative about the great state of Texas, but the Texas Constitution is, 400 pages or so, it's long. It's a lot of basically statutory type language in that Constitution. And Professor Blackman, you probably know that. I like, and I believe it is critically important that the United States Constitution is not that it sets out high-level principles, structures of government, Bill of Rights, things that, how we order us and the balance of power between Washington and the states. My concern about this measure is that it starts getting in the weeds. And when you start getting in the weeds in the Constitution, I think that's a problem. It requires amendment and then amendment and then amendment every time you change your views. If we're going to do anything, why wouldn't there be something here that would say, look, one of the problems we have is that these pardons tend to occur on January 19th or 20th, right? They tend to occur right at the tail end when you're in the lame duck. Maybe you say that you could, maybe if you're going to do a structural limitation that might cut across on a bipartisan basis, maybe say pardons have to be finished prior to elections of the president's, term or something along those lines. I guess what I'm saying is, if you're going to have a reform, wouldn't it be better to have a structural reform like that than something that gets into statutory bases with respect to family members? Are we going to say that John Kennedy couldn't have pardoned Bobby Kennedy if there was something that he felt was important to pardon just because his brother happened to be the attorney general? I don't think that's a good path to go down, in my view. Professor Blackman, do you have any thoughts on that?
Thank you. I actually did some research, and there were many proposed amendments. Representative Barney Frank of Massachusetts proposed an amendment in 2001 that did exactly what you suggested. It would have banned pardons from October through January 21st of any election year. So basically, before the election until after the inauguration, no pardons could be issued. As far as I know, no action was taken in that amendment, but that's almost exactly what you said, sir.
Well, I appreciate that. And I don't even know if that's the right solution. I'm literally just kind of mulling that as we're sitting here talking, because I don't think the right path is to go down in the specifics in the direction that's been laid out here before the committee. And I would only say I appreciate that answer, and I'll yield back my time here in a second. But I just think let's keep this as objective as we can and recognize, I think, a significant amount of work done by the Trump administration to help people with criminal justice reform, cutting across color, faith, et cetera, and that every president has issued some pardons that every single one of us would think was somewhat questionable. I yield back, Mr. Chairman. I appreciate it.
You're welcome, Mr. Roy. I appreciate your questioning, and I'm not wedded to any principle. I want to get ideas, and we'll kind of move from there. Next, we'll recognize another Houston, Texas, another Texan and another Houstonian, Miss Sylvia Garcia.
Thank you, Mr. Chairman, and please know that we've got some great chicken in Texas. I know we're known for barbecue and Tex-Mex, but we also have chicken. So I actually subscribe to a fried chicken blog. So if the interest is fried chicken, I've got the list of the best fried chicken places in Texas. So with that, I want to get to Ms. Frederickson. and ask her a couple of questions. And you mentioned, as Mr. Blackman, and I think Blackburn and even the chairman, a secret pardon. So is there such a thing? Have secret pardons been revealed at a later time? Have there been any? I mean, I'm just really intrigued by the whole notion.
Well, I'm not aware of any secret pardons being revealed after the fact, but there is certainly a question, a legal gray area of whether or not pardons can be issued in secret. Now, the thing that is clear is that if somebody actually is being prosecuted and they want to prevent that, they have to come forward and say they've been pardoned. So in a way, that's how we would have learned if a secret pardon had been issued. But I would like to, if you don't mind, just speak to Congressman Roy's point about bipartisan potential of this issue and the chairman, and to say that certainly I think adding to to consideration structural reforms such as timing issues, but also transparency issues. I think Professor Blackman and I are very much on the same wavelength that a pardon absolutely must be under the public eye. Other things that I think would be really important would be to structure the pardon attorney in such a way that there would be deep involvement, which would also be transparent, which is proposed by the legislation, the transparency of the pardon power, but to structure the pardon attorney role so that there would actually be a more benevolent aspect to it. Because I think one of the rightful criticisms has been that even in the pardon attorney's office, prosecutors are often very reluctant to move forward very worthwhile, legitimate requests for commutation and pardon, and having a more an active presence of those who were seeking justice for those who'd been for over incarceration or for over sentencing for the injustice of the criminal justice system.
Well, you've actually anticipated my line of questioning, because exactly what I was going to ask you next was about the role of DOJ and the pardon attorney, or the section. I'm not sure if it's a section or a division, but one of the things, reports that were out there, is that the former president just ignored any recommendations and pretty much closed their role. And they were not involved in many of the pardons that he did issue. Do you think that was part of the problem with a lot of the criticism that he got in some of his pardons? Would it be a fix that we can make to make sure that it's structured so that there's always a role for DOJ and the pardon attorney?
Well, I mean, I think it's a rightful criticism. One of the aspects of President Trump's pardoning was the very limited role of the pardon attorney, which does serve as an advisory capacity now. But even those very deserving people who were pardoned from the criminal justice system often only received a pardon because of the intervention of a celebrity like Kim Kardashian, and that's unfortunate. Again, as I said, I think there have been criticisms in all administrations of the pardon attorney not being attentive enough to the failures of our criminal justice system, and having a broader understanding of which types of individuals to move forward. It was mentioned how many pardons and commutations President Obama issued, about 1,700. But there were almost 8,000 petitions that were left unaddressed, maybe rightfully so. But again, I think that's because the pardon attorney's office may have some inappropriate, needs to be more affirmatively directed towards recognizing the injustice of our criminal justice system.
Well, thank you. And Mr. Chairman, with only 8 seconds left, I'll go ahead and yield back.
Thank you, Ms. Garcia. I wasn't really thinking of fried chicken. Pascal's in Atlanta is the restaurant I was thinking, and they got the best broiled chicken.
Oh, okay.
But that's just for Ms. Frederickson's information. Mr. Representative Fishbach, you're recognized next.
Well, thank you very, very much. I appreciate that. And I'm coming to you from the beautiful state of Minnesota, where we are below zero here, but I am warm inside. So, but I appreciate the opportunity to just take a couple of minutes. And Mr. Johnson and Mr. McClintock really covered some of the things that I wanted to ask, but I thought that I might just take the opportunity to offer Professor Blackman a few minutes just to expand on that issue of legislative involvement in the presidential pardon issue. It's something that I'm interested in, and
I think I'm
was
just
wondering
tired.
if he had additional comments.
Sure. Well, thank you so much, Representative. I appreciate the chance. I think I'm hearing some interference in the background. It's a little hard to speak. I think it's someone's not on mute. I think the role of Congress here, I think, is important. I think the role, though, should occur after the fact in terms of oversight. In the event that the president issues perhaps a pardon that Congress deems unjust or inappropriate, that's something Congress can investigate. What I would hesitate is to put limitations on whom the president can issue a pardon to and how that pardon can be issued. And I'll just use H.R. 4 as an example. I'll read from it. It says a pardon issued for a corrupt purpose shall be invalid. The amendment does not define what a corrupt purpose is. It leaves it vague. A lot of us here are attorneys, not all of us are. When Congress doesn't define a statute, that lets someone else define it. It can let federal prosecutors define the statute, and it can let courts define the statute, right? It lets courts define this language. And I think if Congress wants to actually prohibit some specific act, they need to do something more than just say a corrupt purpose, because that's not something that's self-evident. That's not a term that everyone understands. Do you think of any term that we argue about in the courts, emolument, right? People argue about these things. So if this body wants to put an amendment to prohibit certain kinds of actions, they should spell them out. What does it mean to be corrupt? I think bribery is already prohibited. I think the Constitution says you can impeach for bribery, and OLC has said you can prosecute perhaps a former president for bribery. But there's a difference between bribery and corruption, right? And corruption is one of these catch-all provisions. I think what Chairman Cohen said, a catch-all provision that can sweep in a lot of conduct that is perhaps unpopular, but I don't think fits within the traditional conception of an illegal offense.
Thank you very much. I will yield back the remainder of my time.
Thank you.
Thank you, Representative Fishback, and stay warm.
Oh, we're trying.
I'm sure. Our next Congressman has 5 minutes. Is another freshman from up the river, Representative Bush.
Thank you, St. Louis, and I thank you also, Chairman, for convening today's crucial hearing. It is without question that Donald Trump did away with all presidential norms. Donald Trump's use of the pardon power will forever be associated with nepotism and corruption. It made clear that under Donald Trump, an act of mercy is given to wealthy donors, well-connected friends, his cronies, and his white supremacist allies. Under Trump, the pardon power became an extension of the privilege afforded to the rich and powerful. Meanwhile, 14,000 clemency applications are languishing in the bureaucracy of the Department of Justice. Thousands of people with no connections to the upper echelons of power and access are left with limited recourse, caged and behind bars as the devastating uncertainty of COVID-19 runs rampant. The pardon power is not the problem. The problem is that it has not been used enough to correct for systemic injustices. Take, for example, Byron Miller. Byron was born and raised in Missouri's 1st District, right here in St. Louis. He was convicted on federal drug charges at 28 years old. He is now 53, living with hypertension and asthma, fearing for his life as COVID-19 makes his way through our prisons. Byron's mother is now 80. His father had cancer, and his daughter was only 6 years old when Byron was sentenced. His absence is deeply felt in his family and in his community. These are the kinds of people our presidents are leaving behind. People like Byron, who are aging behind bars, and others who, had they been sentenced today, would be serving much less time, if any at all. The pardon power was created as a virtually unchecked power of the presidency. This extraordinary power can be a powerful tool of freedom. In the context of our punitive carceral system, the pardon power allows presidents to put humanity over greed, justice over violence, and righteousness over power. Our country is in the midst of a national reckoning on racial justice. For far too long, we have oppressed, exploited, policed, and criminalized Black and Brown communities. We are in need of national healing. This moment requires transformational change, and it's the kind of change that can be done with the stroke of a pen. Ms. Hobart Flynn, you talk about the use of the clemency power as a tool to address racial discrimination. What role can it play in addressing racial disparities in the criminal legal system?
You know, you are right that so many people who did not have access to a process, someone that knew Trump, and this has happened with other presidents, to be clear, Clinton and others, if they don't have someone to help them, that can be a real challenge. You know, Congress can explore legislation to create an independent clemency board to review petitions for pardons and commutations and advise the president, removing the process from the DOJ, because there is a conflict when DOJ prosecutors reject some of the prosecutions that they've had. You know, this could be a check and a new vehicle for this to go directly to the president. I think the president also could look to create and streamline the process for clemency, taking it out of the DOJ. And I would encourage looking at Deborah Leff, who was the pardon, she was in the office of pardon attorney during the Obama administration. As Caroline said, they wanted to move 10,000 commutations. There were a couple problems she faced. One is, as they opened up the stream for people to get applications in, focused on racial justice and excessive sentencing, they didn't have the resources to add staff because Congress was blocking efforts to provide more resources. So Congress can play a role here. Second, she didn't have access to the White House counsel. So setting up a board where you have independent people making recommendations, people inside and outside of the criminal justice system, I think that could be a real tool to move it for others.
Okay, let me ask you this one quick question. We only have a few seconds. In your testimony, you note that racist policies like the war on drugs have disproportionately devastated communities of color, and that you believe that the presidential administration should use the clemency power to remedy these injustices. You know, why do you feel that presidents have been really reluctant in this way? Because it also is worth noting that, well, no, go ahead.
Yeah, no, we have deep problems in our criminal justice system that must be addressed. And clemency is only one tool for racial justice. You know, we have to be looking at all levels, sentencing guidelines. Actually, I don't even think clemency should be limited to something that the president can do. It should be able to be done in courts, in federal courts across the country. So I think, you know, what we have to look at is top to bottom reform.
Thank you. I yield my time.
Thank you, Ms. Bush. Our next congressman to be recognized is someone who played in the NFL so long ago that he never played against Tom Brady, Representative Burgess Owens.
That's putting things in perspective. Thank you so much for that. Well, first of all, good morning, everyone, and my colleagues, subcommittee chair and ranking member. This is truly an honor to be with you. What I'm hoping to do is bring to this committee my long passion for criminal justice reform. I've had a mission for decades. I finally started Second Chance for Youth, working with at-risk kids coming out of the juvenile system and giving them a second chance. And I'm always pleased when Americans are given that second chance. Alice Johnson is a great example of that. A grandmother given a life sentence for her first offense. It took 22 years before someone heard her voice. And that was President Trump. Of course, President Obama for 8 years did not. I want to say something that CNN said about these pardons. CNN, the vast majority of pardons and commutations on Trump's list were doled out to individuals whose cases have been championed by criminal justice reform advocates including people serving lengthy services and low-level offenses. I think we need to lean heavy on the wisdom of our forefathers, and they put a very high bar when it comes down to amendments. It needs to be passed by 2/3 of the House and Senate, and then go to the states, and three-quarters of the state legislators have to also pass. There's a reason why it's been done this way. It's purposely put in place not to be changed by passions and politics every 4 to 8 years, but by reason and time. But that's the difference in a Democrat and democracy and republic. Our republic has lived for 200 years because of this reason over time. What has been the result of that? There's been over 10,000 attempts to change or amend our Constitution. It's only happened 27 times. So we, the people, are the ones that will make this happen. It's not done by a stroke of a pen. It will not be done by legislators every 4 or 8 years. It's done by we, the people. And even though this is very educational, I think this kind of conversation that we need to have so that we can understand this process and understand our Constitution. I can predict that this amendment will not be the 28th. So that being said, I do have a couple questions. Professor Blackman, what are the explicit limits in the Constitution that the founders place on the pardon power?
Thank you, Representative. Only two. The first is that the president can only pardon federal offenses, he can't pardon state offenses. And second, the president can pardon impeachments.
Okay. During the conventional Constitutional Convention, did the founders consider and reject legislative involvement in the president's pardon power? I want to clarify that one.
Yes, there were proposals of having actually the Congress involved, that the Congress have to approve of pardons, and those were rejected. And Madison and others said that we really should put the power of the pardon in a single individual to ensure that there's speed and efficiency, and you can consider justice. As you know, when you have a lot of people in the Congress making decisions, they don't always agree on things. So in this case, a unitary executive does make some sense.
Okay. As I mentioned, this is something we go through almost every 4 to 8 years because it has become somewhat political. But can you kind of characterize President Obama's pardon of Chelsea Manning? It was something that I remember being a big deal for a while. And how does that compare with the majority of President Trump's pardons?
Well, I think the Manning pardon was quite controversial, precisely because WikiLeaks was involved and there was national security implications. But I think I'd make a bigger point. I think perhaps people on the one side of the aisle have a certain conception of the public good, and people on the other side of the aisle have a different conception of public good. I don't think there's a single shared conception, and that's why we have elections. I think President Biden will probably look at different people to pardon than President Trump did, and that's what happens every 4 to 8 years. But I think your point's well taken, that different people think different pardons are controversial for very, very different reasons.
Thank you so much. I'm going to give back my time. Thank you so much. Appreciate it.
Thank you,
sir. We only have about 10 or 12 more minutes of Mr. Naftali, and I'm going to have a beginning of a second round after Ms. Jackson-Lee, and I'd like to use those 5 minutes. So Ms. Jackson-Lee, if you would take your 5 minutes, and if you have anything to direct to Mr. Naftali on the history of pardons, it would be great.
Let me thank you, Mr. Chairman, and the ranking member for holding this committee hearing on this very important issue. It's been stated that the pardon power of the president is not, in fact, unlimited, though governed by the Constitution. I offer these thoughts as I present my issues in the backdrop of January 6th. The unforgivable attack on democracy incited by the 45th president, where his loyalists laid siege to the Capitol building, parading the obscenity of the symbol of the Confederate battle flag while seeking to disrupt the joint meeting of Congress to count and announce the winner of the majority of votes cast by presidential electors, all the while chanting "Hang Mike Pence," culminated a reign of corruption, abuse of power, criminal conduct, unethical behavior, and malfeasance unseen in America, and that weakened our country and made it poorer and left it more divided than ever. As a senior member of this committee, I chose to be on this constitutional committee even as I sit in this last seat, because I believe it is important for us to coddle, protect, nurture, and build the Constitution. I'm delighted with the witnesses that are here, and I want to acknowledge my hometown constituent, Josh Blackman, professor of law, South Texas College of Law. and as well all of the other witnesses, Karen Hobart Flynn, Professor Naftali, and of course the witness of Professor Frederickson. Let me raise this question to Professor Naftali as it relates to the history of the dealing with the importance of the clemency power. And I might add to the fact that not only are people languishing, I, over the years, offered legislation before we had criminal justice reform and sentencing reduction to try to address the tens upon tens and hundreds upon hundreds of elderly African-American or minority incarcerated persons in the federal system based upon the drug siege of the 70s and 80s. So, Professor, would you give us just a historical comment, if you would, on whether or not the president, past president, authority would even reach to the point, if he had reached to attempting to give pardon to those who perpetrated criminal acts under January 6th? And then would you, as a historian, see any parallels between the post-Trump era and the post-Nixon era, during which Congress instituted several good government reforms aimed at reining in potential abuses? And thank you so much for your leadership and scholarship as well.
Thank you, Congresswoman Jackson Lee. After he was acquitted, President acquitted in his Senate trial, President Johnson used the pardon power to pardon Jefferson Davis. It's a Christmas pardon of 1868. It's actually very hard for me to, I get emotional talking about a Reconstruction in the United States. Because I think we as a people, and especially people of color, but we as a people bear a heavy burden because our country did not face the truth of the Civil War and then swept it under the carpet. And I believe the amnesty for Jefferson Davis helped to create that burden. And that was a pardon by a president at the end of his term. I worried, I have to tell you, in January, that we might see some pardons of the insurrectionists. I've spent today talking about Nixon because, not just because I think I know Nixon, but we have evidence we have a shared body of data. And all of you could, I know you're busy people, and you should be, but we can actually all listen. It's there. We don't yet have, but I want us to have it, a shared body of data about the Trump era. We have a lot of public information, but there's a lot more to learn. I have a feeling that the second impeachment, Ms. Jackson Lee, may have actually deterred President Trump from perhaps pardoning some insurrectionists. I don't have evidence, and I don't want to make the claim that he would have, but it is a question I will be asking as a historian. So yes, presidents have had the power to pardon insurrectionists. Indeed, as Professor Blackman would certainly know, I'm mentioning him because he talked about the issue of amnesty. The founders did talk about, perhaps at times, using the pardon to calm our political environment by issuing amnesties. One element of our history that I think really needs to be stressed is that our founders did not think of a partisan era. They did not think in terms of political parties. That's one of the reasons we have the 12th Amendment, because they had to correct the electoral system, at least, and because they hadn't imagined parties. And some of how they conceived of limits on the pardon, I think, are less powerful because they didn't assume there would be a president's party in Congress, because they hadn't thought in those terms. So that's why I'm suggesting structural forms, that because the pardon is too powerful a tool now for a president in a way that the founders, I don't think, anticipated because of the change in the balance of power brought about in a partisan age. One more thing I'd mention. This is a little outside of my lane, but since you've asked a question about reforms too, I believe that the issue of a pardon is not just the issue for the White House, that power resides in the president as our head of state. And therefore, Congress does have a role, perhaps, in expanding knowledge of the pardon to those that could benefit from petitions. The issue is not simply that the petitions get read by the people in the Justice Department and then fed to the White House through some system. It's also that the people in the country who are incarcerated, who are deserving of mercy, know how to communicate their story to Washington. In the case of Donald Trump's era, at the very least, Kim Kardashian was able to provide some of those stories to the man with the pen. But that's a very idiosyncratic way for people who have suffered from unfair incarceration to get their stories before our chief executive. So as we think about limits on the president's misuse of the pardon, we should think of ways to broaden the public's access to that executive clemency.
Thank you, Ms. Jackson-Lee, for asking the professor, and I'd like to follow up with the professor. In your study of the history of impeachment and our pardons, are you familiar with any secret pardons ever being revealed?
No, I'm not. In fact, when that issue arose during the last weeks of the Trump administration, I was learning something. I want to make one other thing clear. I am worried. I am worried about the nature of the climate of power. This is not an artificial concept. Professor Blackman, with whom I agree on a number of points, but Professor Blackman talked about dealing with the problem of the power after the fact. And I'm not sure that the history of the misuse of the pardon suggests that that is enough. Because part of the problem is if the president and his, and someday her, inner circle believe they can get away with it, that has an effect on our judicial and congressional system at that time. If people know that they will be protected, they might not be truthful with Congress. They might not be truthful with the FBI or with the grand jury because of this notion that the climate is permissive. And I think we have had that permissive climate in a number of presidencies. I've documented, and you can learn yourselves about Nixon, and we are now having a debate over the extent to which there was a permissive climate in the Trump administration. But there was certainly at least a permissive climate in the Clinton administration the last day of his second term. That permissive climate is a threat to our constitutional system and to the balance of power that the founders believed in. And I really encourage Congress to be robust in defending its prerogative, in defending the importance of checks and balances. I think the pardon power has gotten out of whack.
Let me ask you this. President Obama, who issued either 1,700 or 1,900, I think it was 1,700 something pardons, he had a system set up at Justice that was rather stringent. I think you had to serve at least 10 years of your sentence, which 9 years of your sentence should have not made some non-violent, victimless drug crime one that shouldn't be pardoned because you'd serve 9 and not 10 years. Has any other president that you're aware of set up a system like that of hoops to go through or criteria and done it in a totally objective manner where they didn't know the person?
I really don't know the nuts and bolts history of the approach to the pardon attorney. I know that for many presidencies, I know in the case of Nixon, ironically, a year before Watergate, the White House was trying to create a better system for pardons. Not every Nixon pardon, by the way, was suspect, but the permissive climate is problematic in that it undermined, I believe, our judicial and congressional systems. But presidents have tried to routinize this approach. And let's keep in mind that the office of the pardon attorney we've had as a people for a long time. It was believed created in the late 19th century. So yes, I think the issue, Mr. Chairman, the issue is when presidents go outside of the system, and it's how often do they do that? When they stay within the system, when they let the experts at DOJ, the civil servants, provide them with data and recommendations, and the Attorney General, of course, plays a role. That's one thing. But when they go outside the system, and we have examples of presidents doing that, I would argue the evidence, it seems clear now, at least, that President Trump went outside of the system more than his predecessors. But whenever they go outside the system, usually, not always, but usually it produces a controversial pardon. That was the case with President Clinton, with President Nixon's contemplated pardons, his dangling the pardons with President George H.W. Bush. So it's how do you keep the president within the system? And that's really the president's prerogative. But there are ways, I think, to complicate the creation of a permissive environment for bad pardons.
Your Atlantic article, which I thought was brilliant, had several suggestions, one of which was the timing and not doing a pardon before the end of the election. Did you consider a president in his first term as different from his second term? Did you consider having to give notice before, instead of election day as a limitation, maybe 10 days before election day, and having notice to make sure it's not a secret pardon? And what are the other reforms you suggested in your article that we should consider?
Mr. Cohen, well, thank you for asking me. I really believe in deterrence because I think we are all imperfect beings. Okay, I think even the best of us faces temptation, and so I think that one of the great deterrents is public sanction. In other words, the public responding to what you've done. That's why, by the way, a secret pardon concerns me, because then the public, by definition, doesn't know about it. But that's why I want presidents to not to fear. I like presidents too, but I want presidents to know that the public has a chance to give a verdict on their pardons. So that's why I very much like former Congressman Frank's idea that you set a structural sort of deadline for the use of the pardon, and you do it before an election, so they can't do it after the public has a chance to respond. And the reason you would do it in October is the public has to know about these things. Now, if you could figure out a way to require disclosure, you could do it in late October rather than October 1st. I think that's a good idea. The second thing is, although the self-pardon, there are lots of good arguments why it shouldn't be constitutional. I leave it to the lawyers. In the Nixon period, they looked at this and they decided that A, it probably wasn't, but B, it had to do with what the Supreme Court would do. And the Supreme Court sent a message in US v. Nixon that even the appointees of the president can vote against the president. So I really believe that I really believe that sanction that should be included, that you should not have self-pardons. And finally, I worry about the president's ability under temptation, partisan temptations, to pardon those who are political associates. And I think that should be looked at hard, a prohibition should be looked at hard as well regarding that.
Thank you, Professor. And I know you have a hard cut. I just got one last question, and I'm going to finish my overtime, and that's to Ms. Frederickson and or to Ms. Hobart Flynn. But first, Ms. Frederickson, the proposals Mr. Schiff has in his bill, Congressman Owens is right. The likelihood of my amendment to the Constitution is a degree of difficulty is great. A statute is not. Are there any problems you have with the proposals that Mr. Schiff has in his bill, and are there additions you think should be in there that could pass constitutional muster and put limits that, such as Professor Naftali and others have discussed?
Well, thank you very much, and to Professor Naftali, I really have enjoyed hearing you speak, and I'm always a fan of historians, being a daughter of a historian. It's a very important part of this conversation. I think the Congressman Schiff's bill puts out some very important reforms, as I had mentioned, which have to do with transparency, ensuring that there's a broader dissemination of information about the pardons, as well as the prosecution that would be pardoned. But also, again, the clarification of the bribery statute, which I think it's widely held that would already apply to the president, but just to ensure that there's no question about that. Beyond that, I think certainly Congress should be considering some of these reforms. They may impose greater challenges in terms of getting closer to the confines of the Article 2 authority that the president has, as circumscribing the grant of pardons in a way that doesn't constitute a prosecution for a criminal offense, which is already seen to be allowable, but actually telling the president when she can not pardon somebody. It's worth considering, but it may be a little bit more challenging in terms of the constitutional limitations.
So on the idea of the secret pardon and trying to prohibit them by requiring some notice to be given, some public disclosure, do you think that could be done statutorily, or is the power in the Constitution so broad that it couldn't be done?
I think it's a gray area. It would certainly be worthwhile for Congress to move forward on the transparency issues, the transparency provisions that are included in Congressman Schiff's bill and in Mr. Krishnamurti's bill, but also to look at timing issues. It certainly sets out a very important viewpoint of Congress's role in understanding the Constitution, which Professor Blackman rightly says Congress plays a very important role in the interpretive process, and sends a strong message. So I think there's a possible constitutional challenge. I wouldn't endorse, but I certainly would be something that would occur. But I think it would still merit going forward and pursuing such reforms, because I think they might certainly stimulate an administration to try and adhere to them. And if an administration did not, it would provoke its own political backlash.
Thank you, Ms. Frederickson. If I've gone over time and taken that opportunity to ask each of you and Mr. Naftali questions, does Mr. Johnson or anybody else in the committee desire any additional time, or should we close this hearing up?
I'll take it if it's offered, Mr. Chairman, just another 5 minutes or less.
Or less, thank you.
Just quickly, there's been a lot said. I actually think it was a productive discussion today, and I appreciate that and the tone that everybody brought to the discussion. It's important. And as we've acknowledged, there's been people politically aggrieved on either side of this, depending on who the president's been. But I do want to just point out, some things have been said about President Trump this morning. He's been accused of not only, in one sense, going outside the system, as it was said a few moments ago, to, egregious violations of the pardon power. But I just wanted to ask Professor Blackman to just kind of put a bow on all this. I mentioned in my opening, President Trump granted nearly 240 pardons and commutations. And, we've heard a lot this morning about how he abused the pardon power, but according to the Pew Research Center, President Trump used, quote, the power less frequently than nearly every other president since the turn of the 20th century. Professor Blackman, I just wanted to ask you, would you agree that the grants of clemency and pardon and all that President Trump used was done by him, at least from his subjective viewpoint, in a way to rectify unjust sentences and prosecutions?
I think so. Maybe I'll focus on one in particular, Jack Johnson, who was a very famous boxer from the early 20th century, an African-American boxer. He was charged with violating the Mann Act, which, if you don't know what the Mann Act is, it's basically this very nebulous law that prohibited transporting women across state lines for immoral purposes. He had a mistress who happened to be white, and he was charged with basically having a relationship with a white woman, and he was sentenced to time in prison. This was almost 100 years ago, and this was a pardon that probably should have come some time ago. And I think it was one of the more commendable pardons that President Trump issued. I think it's worthwhile to stress here.
Thanks for mentioning that. And I point out that he was, my son is named Jack Johnson. We take a lot of pride in this. Wow. Johnson, the boxer, was convicted by an all-white jury for that crime that you said. And of course, civil rights groups and advocates petitioned past presidents many times to officially recognize that his prosecution and conviction embodied racial hostility and intolerance. And it took until the time of President Trump to correct that historical injustice. So it was mentioned Alice Johnson, another for the drug-related offense. The point is that I guess what I want to conclude here at the end, Mr. Chairman, is to make the point for history, for the historians and the lawyers and all of us who are involved in this, that there have been controversial pardons by almost every president, but there have also been some very noble things that have been done before, and President Trump certainly did the latter, and I wanted to note that for the record. So I will. I know we're over our time, and I'll yield back, Mr. Chairman. I appreciate again the tone and the content of the discussion this morning.
Mr. Chairman, I'd like to comment. I think I have my hand up.
Sure, Ms. Jackson-Lee, you're recognized.
Well, thank you so very much, Mr. Chairman. Very important hearing, and I'll be brief on my comments. Professor Naftali, thank you for giving us not only food for thought, but a structural roadmap along with the legislation that we're now looking to assess. I gave those opening remarks specifically because, as you well know, that was the height of the discussion and intense discussion as to whether the president would, in actuality, pardon those domestic terrorists, those insurrectionists. And it was a frightening possibility. I also want to say that I've lived for a long time on this committee with the teeming numbers of individuals in the federal prison system who are predominantly African American or people of color. Visited some of them, had people, families petition and beg for some relief. It is a painful experience to see your neighbors incarcerated under these mandatory minimums and could not be released or access to it. So you gave an interesting point about structuring the structure of it and the potential of Congress and also information. I thank you for that. But I wanted to conclude my remarks by saying that this is an important agenda and reform is important. The Constitution is precious. It's a precious document. Thank you for your historical perspective. And I think that we should continue to recognize that this document has lasted for a period of time that pushes us to protect it prospectively and to be serious about protecting it. And so I look forward to Mr. Chairman on this. Finally, let me offer my deepest sympathy to my late colleague, Congressman Wright, Congressman from Texas, for obviously his tragic loss, and to say that I know that he was dedicated to the service of this nation, and I know that his constituents and the nation is grateful for his dedication. Thank you, Mr. Chairman, and I yield back.
Thank you, Ms. Jackson-Lee. And I believe Mr. Hank Johnson has asked for a few minutes. I think he's the only person who has, and if with the permission of the committee and the indulgence, we'll recognize Mr. Johnson for our last round of questioning.
Thank you, Mr. Chairman. Professor Blackman, it would be fair to say that President Trump was rather stingy in his use of the pardon power compared to President Obama. Is that correct?
I think he should fear them, absolutely.
Yeah, in fact, Trump pardoned 143 and commuted 94 sentences. And Obama, in his 8 years, pardoned 212 and commuted 1,715 sentences. Would it be fair to say that President Trump commuting sentences showed more mercy than President Trump, who just simply let a bunch of folks off the hook, particularly in the wee hours of the morning on the night of January 19th? He issued, of his 237 total pardons and commutations, Trump commuted or pardoned more than 140 people in the wee hours of the morning, just 10 hours before his term ended, including Steve Bannon, a potential witness against him who was under indictment for defrauding Trump supporters in a build the wall scheme. Professor Blackman, would it be fair to say that it's best for the use of it's best for presidents to depend on the office of the pardon attorney rather than simply dispensing pardons and commutations out of their back pocket like President Trump did?
Well, I thank you for the question, Representative. The Constitution gives the president this power. The pardon attorney can make recommendations. I actually agree with Ms. Frederickson. It may make sense to have people who aren't in DOJ making these recommendations because very often DOJ is supporting the prosecutions. I think having
Well,
someone who
how many times did President Trump rely upon the office of pardon attorney before making any of his 237 commutations?
I don't know, but I guess the number is pretty small.
And how many did President Obama do under the office of the pardon attorney?
I don't know the number. I'm guessing it's a bigger number.
Yeah, I think it was a total of 1,927 that he relied on the office of the pardon attorney. Professor Frederickson, what is the better practice in terms of use of the pardon power, and how can we best protect our democracy from being undermined by the illicit use of the pardon power as we saw happen under the Trump administration?
Well, I'd like to first thank you for that question. It's a very important one, and I'd like to associate myself with the remarks of my colleague Karen Hobart Flynn, who talked about the need really to have a wholesale reform of our criminal justice system and its disparate impact, particularly on Black and Brown people. The pardon power is one element of that, but it's not sufficient, clearly, in the commutation. But having a system inside the Justice Department, or I think a better practice, as Ms. Hobart Flynn also suggested, is perhaps a kind of a board that was made up of people who weren't all prosecutors, who would be considering the real injustice that's been done and who can be, whose sentences can be commuted or who can be pardoned through the president's pardon power. But that I think is very insufficient. Because there are so many people who are prosecuted for low-level drug offenses who are already in prison for excess of time that we unlikely to address all those people through the pardon attorney process or through any kind of a commutation and pardon board. Nonetheless, though, I think it's very important to have a system that does allow the most significant cases to move forward and be put in front of such a board or in front of the pardon attorney for expedited process.
Thank you. And thank you, Mr. Chairman. I yield back.
You're welcome, Mr. Johnson. I've been told by staff that Ms. Bush might have a question. Is that correct? Representative Bush? Representative Bush going once, going twice. This adjourns. That concludes our hearing. I want to thank all of our witnesses for appearing today. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. And I would like to specifically ask our witnesses if you have thoughts about legislation, either the amendment to the Constitution or, as Representative Owens has cautioned, more likely statutory changes, and suggest them in your comments to the chair, because we are going to try to draft something that is feasible, passable, and improving things. So if you have suggestions that we could do for amendments to Mr. Schiff's statutory, that would be appreciated greatly. With that being said and done, and in memory of Representative Wright, Congressman Wright, this hearing is adjourned.
Thank you, Mr. Chairman.